And here we are back for our fifth episode of unCOMPlex. Last month in April, we were fortunate to have Judge Hedler fill in as I was unavailable, as sometimes I am. Today, I'm joined by Judge Almeyda, who
Hello.
is in the Miami District. Judge Almeyda, do you know what makes you superlative in terms of all 250 judges that have ever served as a workers' comp adjudicator in Florida? What makes you different?
Two things make me different. The first of all is that I've served as started out as an adjuster, then I did defense work, then I did the claimants work, then I had an employee when I had my practice got injured and made a workers' comp claim against me, and then when I was twice, I filed a first report of injury. The last time the state controverted it, and I'll explain. That's a funny one. I've served as a mediator, and I've served as a judge, and I've served as a professor of law of workers' comp at Nova. The other one
Okay.
is I'm senior to everybody.
You may not know this, but this is the truth. I've done some exhaustive research, and you are the oldest individual ever appointed as a judge. You were that 68 years old was your first appointment.
Chronologically, I'm old.
That's that's pretty impressive. I was telling one of the other judges earlier today, the youngest ever appointed was 23.
Well,
So yeah, we had a deputy commissioner appointed at 23 years old. Anyway, so we're thinking about talking about comp. Before we went on the record and started recording for the podcast, you were saying some things I want to come back to, but at the outset of these things, I'd like to remind folks what we've got coming up. The judges and mediators are going to be together again at the Workers' Compensation Institute in August this year. And so we're looking forward to perhaps meeting and greeting folks there. If people are planning their calendars, that is going to be August 18 through 21. And as we did last year, we're going to have a meet and greet at 5:30 p.m. on the 18th. And that's going to be in Anaheim, Boston, and another room. But the three rooms are all strung together there. If you remember Anaheim and Boston, um, we're going to just be there to meet and greet people and sort of have an opportunity to hear what's on folks' minds. And we hope to see everybody there. That's really the only announcement of upcoming that we have. Things that have happened in the past on our YouTube channel, we have now deployed all of the recordings are now deployed from the March 1, 2024 OJCC seminar that was at the First District Court of Appeal. And some of you may know that Judge Hedler was in charge of shepherding everybody and planning that this last year. So all of those are recorded. We know there are a couple of glitches in those recordings, so you don't need to email and tell me when you run into those glitches. But technology can be somewhat difficult to deal with at times. There was a famous comedian once said, if you want to make successful in show business, never work with children or animals. And I say that's probably true, but I also like to add, don't work with technology either, because it'll get you just as often. So those are our announcements. Oh, I'm sorry, one more. We are adding to our YouTube channel. We just started work on an archive of hearings and trials that the judges think are interesting and educational. And so if you follow us on YouTube, you'll see those start to go up probably in the next 4 to 5 days. And we're trying to give you some examples. Oftentimes on this podcast, we've had our viewers ask us where they could go to watch trials. If you, the viewers, have trials that you're particularly interested in because you've seen the judge's order or you've seen an appellate decision and you'd like to see that trial on YouTube, send me an email and we'll be happy to consider putting that up for you. But back to Judge Almeyda, you interestingly, to me at least, mentioned before we started recording the challenge that you're having with professionalism among practitioners and their preparation. Would you repeat that story and tell us what's going on?
Well, professionalism, it's unfortunately gone by the wayside in my experience of 50 years as a member of the bar. This specifically this week, I had a final hearing with an unrepresented employer, carrier. They weren't present at the hearing, and already had entered an order on a bifurcated matter finding the case compensable. And all they had to do was come in and prove the
Sorry, Judge, I've muted you. Please unmute. Judge? Now that's not good.
I'm unmuted now. Can you
There
hear
you
me?
go. Yes, thank you. I'm sorry.
All right, let me start. I just had a hearing with an unrepresented employer carrier. They weren't present. There was an order finding compensability and bifurcated. And all they had to do was prove a period of disability and medical bills that were due and medical treatment that may be due. After an hour of testimony on an unprepared witness claimant, I looked at the exhibits while they were testifying that the medical that was offered. I didn't have any medical bills, and I don't have any medical opinion on the matters that were just attached, which is just routine copies of the records of any period of disability. So that's, to me, sad because it totally shows unpreparedness to come to trial. And this is something that I have seen in the last decade or so, that lawyers assume that workers' comp, because it's easy, there's non-jury, the judges are, for the most part, nice individuals. They can get away with it, and they come and treat this as a without any respect. And that's unprofessional and probably also unethical because it shows lack of preparation. And I have seen now it's just become more than epidemic, it's become an endemic. It's worldwide. I mean, as far as the statewide from the cases that I've had. And I had one not too long ago where I was trying a case involving out of Miami venue, where the first thing I look at if there's indemnity claimed is there a agreement or a proof to be adduced on average weekly wage. And I asked what is going to be happening reference to average weekly wage. And to my shock, they said, oh, we'll work on that later after you're into the order. So that's, and I urge you lawyers to please prepare for this cases as if it were your last case and it was your mother that was the claimant.
Well, that's kind of the point. I think people forget this, but the most important case that's ever going to be tried in the history of law is going to be the case that is tried today. And for somebody involved, whether it's the employer or the injured worker, this is the only case they've got. This is the most important case in the world to them. And I think if we're not showing that dignity and respect, I think it's beyond disrespectful. I think it's disgraceful. We can put on a tie, we can put on a jacket, we can treat people with dignity and treat them like what they're trying to do matters. I'm seeing a decline in that. Are you perceiving that people just are not treating folks with dignity and respect?
Unfortunately so. And among the litigants, uh, they're so keen on winning and making money that they forget that they are on the other side as a brother lawyer or sister lawyer. And it's just become a dog eat dog. And if I could go back historically a little bit, I saw this happen in the advent of the 79 law when they made bad faith the form to get attorney's fees. Prior to that, this used to be a somewhat close fraternity sorority where the lawyers treated each other with respect and accomplished a lot in a phone call or face-to-face communication. When they had to prove fees by showing bad faith, that created an element of adversarial litigation that had not existed. And that was the cornerstone, the birthplace of the current advocacy that we have, where the lawyers go at each other, they go against carriers, and basically it's borderlines into some. I've seen cases where they actually hate each other, the litigants, which is shouldn't happen. There's no room to hate the other lawyer because he or she is just doing the job like you are, trying to make a buck and trying to succeed in proving their client doesn't owe anything or owes something. So that's it.
So you think 79 is the is where that started, the instigation point, but I don't know. I've perceived that things have gotten more troublesome, frankly, in the last 5 years with this COVID and the people's reaction to COVID. And I think it's being intertwined with a generation of folks who would rather pick one of these things up and use it in their hands than put it to the side of their head and talk to somebody. You think it's worse the last 4 or 5 years, or am I overblowing that?
No, what I said is 79 was the birthplace or the foundation of the current problem that we have. Every year it gets worse, and every year I've been I started as a mediator in I forgot '07 I think, and as a judge in 12 or 13, and I have seen it decline every day since then, and it's gotten to the point that it's frightening to see what's happening because I projected into the future and we might as well carry guns into the courtroom and have a shootout to probably be more effective. Probably more effective some of the arguments I've seen too, by the way, and I'm being harsh there.
Mm. Yeah, we don't want to condone violence, but I get the analogy that I just don't get the impression people are communicating with each other. They're not talking with each other. Um, I think they're talking at each other when they talk at all. They're not spending a lot of time listening, digesting what someone has to say, and sort of considering that other perspective. I think that's a recipe for disaster in litigation because, frankly, if I'm not listening to what the other side is saying, then I'm not I'm not paying attention to what the judge is hearing, and the judge may be persuaded by that. I really need to hear what the other side of the case is saying so that I can counter it. And I think that's missing. What are you perceiving on that? Anything?
Well, right, uh, an effective lawyer in a law firm, and I had this when I had my law firm with well, some of them my partners are judges now. Uh, we took one of the lawyers in the firm took the other side of the case and became the devil's advocate. And it taught us to hear what the other side was saying, to prepare to counter it, but now they don't. Uh, I've had cases uh, where there was an objection to a question, and I looked at the lawyer, and I happened to read everything prior to the final hearing, and I said, I don't understand why you're objecting to this question when in the deposition you asked the same question and got an answer, and you put the deposition in evidence yourself. And what happened is that particular lawyer in a big law firm wasn't uh, doing the preparation herself, and she was letting a clerk prepare, and she was reading the cliff notes that the clerk prepared. But going back to what you said, communication, the technology today has broken down communication while it should have enhanced it. In my days when I was practicing at the beginning, you picked up the phone and you called somebody and you probably got to the secretary, maybe a receptionist and then a secretary, and you left a message and they wrote it down into a pink slip and they put it on the desk. And then we now have become technologically sophisticated. So you either leave a voicemail to the secretary or to the person that they don't have to listen to because they don't have to go into that box, or you send an email, and the emails usually go to the paralegal or legal assistant or whatever you call the assistant to the attorney, and they may or may not read it, and then they may or may not tell the lawyer. So that one-to-one communication where you would pick up the phone and say, Joe or Deborah, what are we going to do with this case? Where are we going? Or you ask the question, what is it going to take to resolve it? Or sometimes we would ask a question was, not a question, but you had a problem with a deposition that you couldn't attend to. And you were candid with the person. You say, Joe or Deborah, uh, I can't go to the deposition because my wife's got to go to the doctor and I want to go with her. And everybody would accommodate each other. But now there's no communication like that. If there's an email, there's an email, but who gets the email? And then you get a motion for protective order. And this is what the breakdown that I have seen, the breakdown of communication.
Well, I think the judges as a whole are spending a lot of their time dealing with these motions for protective order or motions to strike or motions to compel. And I perceive that those are a lot more frequent today than they were 5 years, 10 years ago. And so from my perspective, it seems like either our professionalism is diminishing or I'm just noticing it more. And I'm not positive where I come out on that.
Well, again, going back historically, very few motions to compel were filed. You pick up the phone and talk to somebody, and you'd say, hey, I need 10 days or 20 days or whatever, and you'd usually get it granted. That doesn't happen today because if you picked up your opposing counsel, odds are you can't get hold of them, and then the bigger odds are that they don't return the call. That seems to be the way it is today.
Well,
So
it used to be we ran into each other at the comp office though too.
that back in the days when Miami had the office at 401, at any given point, you'd see the whole workers' comp bar there, particularly on Friday at pretrial days, because a lot of pretrials were live and motions were live and everybody. So now that doesn't happen.
And and maybe the only place you run into other lawyers face to face is at an ends of court meeting or a local bar association meeting. But honestly, I don't perceive those as being a frequent event. Those are maybe monthly at best, or are they more frequent? You're in the ends of court, I think.
I'm not active in it, but it's once a month meeting.
Um,
So it's not before when uh, workers' comp was hot and heavy in Miami and at the 401, and then later on downtown Miami when we went to South Tower, that was full of litigants, lawyers, and people would talk to each other. And when the motions by being live, you see the lawyer before the motion on the reception room, and you get a chance to talk to the individual. And odds are you not resolve the issue, you narrow down the issue. But now by remote and by phone or Zoom, uh, that's the first time they talk about it because the other thing that I have seen is the good faith attempt to resolve. They should just do away with that because nobody adheres to it. I don't think in 100 motions the two lawyers talked in a good faith to resolve it. Either they sent an email that nobody read, or went to the paralegal or legal assistant, or most often than not, lately I've seen that they certify that they made an effort and they don't. And the most ridiculous one that I have seen was a 2-minute effort. They tried to communicate by email, and 2 minutes later they filed a motion. This is why they should do away with it, because it's encouraging the non-adherence to the tenets of that is permitting a violation of ethics and the law and the rule, and it's going uncondoned.
so when you get that motion that's the 2-minute good faith, do you deny it summarily as violating the rule, or do you consider it on its merits?
Well, I just entered an order on that, and I did some research, and I'm not sure that the rule requires or allows us to measure what is good faith. The rule in the motion, as well as in the petition, requires that it be certified that you, in good faith, made an effort to resolve it. And there's a case involving the petitions. As long as you certify that you did it, the judge cannot dismiss the petition. And I think the same applies to motions. As long as they certify that they do it, you can't dismiss it. If they don't certify it, then by rule it's mandatory that the petition be dismissed. I've had the latest round of litigation I have in a case involves that issue where I just entered an order if a party feels that the good faith effort was fraudulent or non-existent or they should file a motion for sanctions and I'll have a hearing on it. Let both parties say what they tried. But to me, the good faith effort to resolve a motion has become a joke. And which is the sad part of it that I see, the lack of respect that the bar has for workers' comp and as such for workers' comp judges because they think it's a joke and it's sad and I've seen the decline. Uh,
So you think the better solution is just to take that out of the rule and admit defeat and just roll with the punches. It becomes more combative and more uh, mercenary, if you will, and we just accept that that it's going on and that people are telling lies, and we put them in a better position where they don't have to tell lies anymore.
right, they should just take it out. It's encouraging lying and that's what's happening in most cases.
Hmm. You think that would improve or cause cases to move more readily through the system?
No, I don't think it would affect the how the cases move. It would affect the lawyers having to say that they did something that they didn't do, which bothers me immensely because I I'm old school and I was brought up by my father not to lie. And I'm old school and I was taught in ethics at Florida State, you don't lie to a judge. And unfortunately, I see that happening today.
Yeah, that's intriguing in itself. I never really thought about that. How does a guy get from Miami, Florida, up to Tallahassee to go to law school? What drew you that far north, Judge?
Well, this is a sad story, Judge, and I hate to tell you, but I was dating this girl named Sharon who was real cute, and I wanted to go to University of Florida to study architecture. But Sharon went to Florida State, and I wanted to be with Sharon, so I dropped out of Florida, out of architecture, and went into business so I could go to Florida State.
So you could have been Frank Lloyd Wright, and instead you've become the senior judge on the workers' compensation bench. Their loss, our gain.
A lot of lawyers feel that is your loss, but I think it was architecture's gain because I was one of the few students who couldn't draw a straight line straight or make a curved line curve. So the professors were rather happy when I dropped out of architecture, and I think they had a party that night.
Wow. That's intriguing that you would end up that far north. Florida State is definitely a different environment. Um, the other thing I've been noticing recently is a lot more motions to compel settlement. I sense that we've got a lack of communication, perhaps between claimants counsel and their client. Perhaps claimants are not hearing what the mediators are saying. Maybe it's just the fact that we're using Zoom a lot. I don't know. What's your perspective? Do you feel like you're seeing more motions to compel than you were 5 years ago?
Oh, yes, definitely. 20 years ago, you never saw those. And today I usually get one or two or three a week.
Huh.
And most of them are it's a matter of communication. Very few of those motions end up at a hearing where the claimant withdraws from the settlement, and I got to find out whether it's enforced or not. Most of the motions to compel settlement are that the settlement papers were sent to the lawyer in February, and the defense lawyer hasn't received them yet, so they filed a motion. And I set them down for hearing, an evidentiary hearing, and 99.9% of them go away before the hearing, usually shortly before the hearing.
So that's right back to communication. It's not really a misunderstanding. It's just a failure to communicate.
Failure to communicate, failure. Uh, in the old days, when I've always done claimant and defense work. My first job was as an attorney in workers' comp. Well, I started doing workers' comp right out of law school. But I also did liability. I did aviation litigation. That was my specialty. And comp was my sideline. But in either event, if you represented somebody, they usually came to your office and you sat down and you spoke with them. And later on, periodically they would come to your office and they would speak with them. And prior to a deposition, you'd have an office conference where you prepared them, so on and so forth. Nowadays, unfortunately, and I have seen cases where I've actually had this matter come up at trial, the claimant is signed up at home by what used to be called a runner, but today is not called that because it's not politically correct. And the only communication the claimant has with a lawyer is through the secretary sometimes. So, and maybe they communicate at the time of the mediation, but a lawyer that attends to mediation is not the lawyer that they think represents them. So what happens is the settlement is done and the claimant, they never call the claimant or the claimant doesn't know who's calling them. And I've had that happen, brought up in testimony in cases. And finally, I just got frustrated. I said, well, why don't we just postpone this for 5 days and let you guys speak to each other actually. And then 5 days later, I get the papers. So it's a total breakdown of communication, which goes back to the lack of respect because everybody is taking this as a joke. And in the old days, I was taught that if you represented somebody, you met them face to face, you found out what they needed, you found out what they wanted, you found out what was lacking in what they needed, and then you proceeded. Not anymore.
Yeah, we see some communication breakdowns. I was just reviewing a situation where a lawyer represented a gentleman who was in a non-cognitive state. He was in a coma, and this gentleman had no blood relatives, but the lawyer purported to represent this injured worker. And I said, well, how did this injured worker hire you? Well, he didn't. His girlfriend hired me. And I said, okay, well, who said that the girlfriend has any right to pursue benefits or pursue relief on behalf of this individual who's in a coma? And the lawyer's response to me was, well, who else would do it? And from my perspective, looking at it from a legal standpoint, it really made me wonder because I think you probably have to go to circuit court in that situation and get a circuit judge to assign someone to represent that injured worker's best interest. You think I'm missing the point on that? Can a lawyer represent someone who's not competent to hire them?
Yes and no. First of all, you're right about the circuit court. Now, you as a judge of compensation claims have a statutory duty, and I forgot the name of the number of the statute. I think it might be 29, but I'd have to look it up, where you can refer or certify the matter to the circuit court for the appointment of I guess it would be a guardian ad litem or whatever you want to call it in this particular case. And then that individual that's appointed by the circuit court has the capacity and duty in this case, if the person is in a coma, to hire you and as a or hire a claimant's lawyer. But if a judge has knowledge that the claimant is incapacitated or is a minor, the judge cannot proceed with the case until the circuit court appoints an administrator for the handling of that person.
Yeah, I've found great mystery in that because I just don't understand how the lawyer can say that they represent someone who's not competent to sign a contract of representation. It seems like a dicey situation, but I'm afraid out there in the real world, it's something that comes up from time to time. Unfortunately, there are some very serious accidents that happen.
Yeah.
So I don't know the right answer to that, but that's sort of troubled me since that came across my desk, and I've given it a lot of thought. I'm not sure I know the answer, but jurisdictionally, I've got some challenges or some questions with it.
Well, I'd have to look at the statute number, but it's you have a duty at that point to stop the proceeding and refer it to the circuit court.
And of course, no one's ever going to be happy with that answer because we all know that things in circuit court take time. Um, and they just are always going to naturally take time. And I think we're in a better position to deal with issues rapidly than the circuit court is, but I just don't think we have jurisdiction. I think it's their problem.
The cases I've seen involving that where a guardian has been appointed usually delays it by about 6 months. It's been in Dade County. I don't know in other counties where maybe smaller and things may proceed faster. But it usually takes about 6 months. Now, the other problem you have if you as a JCC refer it to the circuit court, some circuit court judges don't understand the relationship that there is between a JCC and a circuit court judge. So what I did in the case that actually the lawyers didn't pursue the opening the estate to have a guardianship, where I actually referred it to the circuit court for guardianship. I called the chief judge of the local at Miami, and I talked to her and I explained to her what I was doing, and I sent her the documents. And understanding that, she then assigned it to the right judge and moved it along. But if it goes back to, I just had this matter come up. I think it was Monday. Yeah, Monday at a hearing Monday in Miami. Uh, we They wanted to refer a witness who violated a subpoena to the circuit court for violation of subpoena, and possibly circuit court find him in contempt. And I explained to the lawyer, the claimant's lawyer, who has a trial coming up in June or July. I said, I very well have the authority, the power, and if not the duty to do so, but I want to make sure that you understand what you're getting into. Because if that happens, you're looking at 6, 8 months down the road that you're not going to get any relief, if that much. So he said, no, I don't want to delay the case, and dropped it. So that's the communication between the JCC and the circuit court in a big county like Miami. It's might be different than a small county where you only have a few circuit court judges.
And your example illustrates a dichotomy in the problem. A 6, 8 month delay in getting relief from the circuit court to make a case move forward is certainly important.
Yeah,
But I think about a 6 month delay while somebody lays in a hospital bed in a coma, unable to get their case started. And I think that's way too much delay. If I was laying in a coma in a hospital bed, I would hope that somebody could start working on getting me some help a little more rapidly than Halloween. But that's what the reality dictates.
yeah.
It's troubling.
Which brings another matter that I encounter a couple of times a month in Miami, where you file an emergency motion to uh, on the blood workup, the hospital to release. Well, first of all, they want to preserve the testing, and but you don't know that most hospitals preserve it for up to a year, and then to release the testing. And they put in there that the claimant is hospitalized and incapacitated, and so on and so forth. And just looking at the four corners of the motion tells me that I can't rule on it because the person, number one, is incapacitated. They need a guardian.
Yeah.
And to any of the judges that are listening to this, we all deal with it differently. But I feel that, looking at it from a purely legal perspective, four corners of the law test in jurisdiction 101, we have to appoint a guardian or wait till a guardian is appointed, but it doesn't happen.
No, it's a sense of urgency that's being conveyed. I don't know. With some people, I'm hearing that the word emergency has become a punchline.
Yeah,
There are perceptions that that certain lawyers think everything is an emergency. And so every motion that comes in from a particular lawyer says it's an emergency motion. Um, I don't know. You think that term's being overused, emergency?
absolutely, absolutely. I didn't used to see any emergency motions. Now I see one or two a week, and some of them is because it's overused and they just want to get a ruling quick. But the other one is the lack of diligence. And I entered a strong order on lack of diligence, which order is on appeal, by the way, on certiorari. And they filed an emergency protective order on an IME. And in my order, a very strong order, I said the lack of diligence on the part of the claimant's lawyer is what created this emergency on a matter that's been before them on their desk for the last 35 days. And I denied the motion for lack of diligence and not an emergency. They took me up on appeal, so it's up there.
Well, in the grand scheme of things, that's a conversation I had with another judge here about a week ago. The appellate process is many things. It's collegial and it's cooperative and it's going to involve a lot more brains, and that's wonderful. They make their decisions in panels of 3. But if we make a decision based on the old emergency motion, there's always the opportunity somebody could take an appeal. So if you decide a case on an emergency motion, that may delay things months, where you could just instead wait until the time is ripe for a regular hearing instead of an emergency hearing, and maybe avoid that appeal. Now, on the other side, maybe that'll get appealed also. There's no telling. But emergency motions really trouble me because of the inherent conflict between needing to do something rapidly and needing to do something that is right, and maybe forestalling that potential for appeal. I don't know. You perceive things are coming back from the appellate court rapidly or not so rapidly?
Now, the appellate court, if I look at my appeals, for a while there, it was about 8 months turnaround, 8, 9 months. Now it's over a year, and the last one that I came down, I won't mention it, but the one that was a year and a half, close to 2 years. So, and I don't understand, because the number of cases that are coming down on the appellate system for workers' comp have diminished substantially because the number of trials have diminished. It used to be, I look at the DCA every day to see what they decided, and you could see a lot of workers' comp cases in a period of a month, 2 or 3. Now you can go 3 months and not see a workers' comp case. So I don't know why it's taking them so long.
Well, they did lose some judges. And you can talk about the jurisdiction. A lot of people don't think about this too much, but when they carved out the 6th DCA, they carved up the state population a little differently. The number of judges in the 1st district went down, but nothing changed with the appellate jurisdiction for workers' comp. They still get 100% of those appeals from around the state, but now they're dealing with it with 3 less judges than they had 2 years ago. So that may be part of the delay. I don't know. How do you feel about the 1st district hearing all of the appeals? You've been around long enough. You remember the old Industrial Relations Commission. Wasn't
Right.
that even slower?
Now the IRC was a lot faster. By the way, to those of you listening who never heard of it or don't know what it is, the appeals up until 1979 were done to a administrative body called the Industrial Relations Commission. Workers' comp, the nomenclature was that the Industrial Relations Commission constituted the full commissioners, and the trial individuals were called deputy commissioners. That the names changed, has fluctuated, but in 79, the IRC, or Industrial Relations Commission, was abolished, and then we formally became judges of compensation claims. Now, when the appeals were to the Industrial Relations Commission, there were 3 commissioners, similar to the Judicial Nominating Commission, one appointed by industry, one appointed by the bar, and the third one I thought it was appointed by the governor. And there were several commissioners, but the appeal were heard by 3. The appeals were just about the same. The format of the brief and all of that is the same. Obviously, its variations have gone by with the rules. The appeals were quicker. Most of the appeals resulted in oral argument. The oral argument was in Tallahassee at the FIC building, or Florida Industrial Commission, building. And then from there, the IRC appeals at the tail end of it. I'm not going to give you a long history because it's fluctuated. Were done by certiorari to the Supreme Court, and the test was essential departure from law. And it all became very political. In '79, the Supreme Court did not want to see any more workers' comp because they had to hear a lot since they were receiving the first appeal from a administrative instead of a constitutional court. So they wanted to get rid of it, and politically, then they made the appeals go to the First District Court of Appeal in Tallahassee, and that way they could wash their hands. And now the appellate record, the appeals to the Supreme Court are few and far apart and very difficult to make. How do I feel about the first DCA? I think it's the best system that we had because right now, right then and there, you go right to a one court in Florida that covers the entire state and enters an opinion that affects it. Before, when we had the IRC and then we had the Supreme Court, at one point or another, the appeals went to the local district court of where the accident happened, which created conflict and certiorari to the Supreme Court. So now we have one opinion that says, like Miles, this is it, and we all abide by it.
Yeah, you know, people may not realize this, so I'll throw in a plug on our website. We've actually given everybody access to the IRC decisions. So if folks are looking for those decisions as they do research, and you're seeing those cited in older cases, if you go to our website and click on the Orders Search tab, there's a sub-tab for IRC orders that'll let you search those by keyword, just like you can any other search. We don't have the FICs. Judge Almeyda didn't mention that before the IRC, back before 1968, we had the Florida Industrial Commission, which he mentioned they're building. But back in those days, we had the FIC decisions, and that book is what they looked like. You'd be lucky if you can find one of these anywhere. There were 9 volumes total. They published their opinions primarily in the 50s and 60s until the FIC was basically disbanded in favor of the Commerce Department when the Commerce Department was formed in 1968. So we've been through some evolutions and some changes. And that was 68. So of course you didn't have to deal with the FIC, Judge. Did when you got started in this practice, did you ever have any conversations with people about the FIC and what its strengths or weaknesses might have been?
No, not really. Even though at the beginning I was taught by the lawyers that were the backbone of workers' comp. They were too worried about what was happening currently, and I'd hear chatter about the good old days, but I wasn't paying attention to it.
All right. Well, who were the backbone? Who were those lawyers that were the backbone of comp in those days?
Well, in Dade County, in defense, they had Jack Miller, Dick Hodges, that now have morphed into MKRS. They're both passed on. Summers Gordon was a real heavy hitter. Fortunately, I was trained by Earl Cornell, who was also a heavy hitter. And Bob Gregory was also a heavy hitter, doing defense work. And on the claimant side, Howard Pelsner was there, and he was a real heavy hitter. They had Levine, Bush, Knepper, and Stein. They, at one point or another, they had so many cases and made so much money that they made headlines in the Miami Herald. And like I'll give you an example. I worked for Earl Cornell, later on became Cornell Almeyda, but in the same building where in the same floor where I was, they had Miller Hodges and George Kagan, and then they had Gregory and Summers Gordon. Earl and I were on the same floor, and we'd go to lunch together. So it was the backbone of workers' comp talking to each other. Now they're all spread around and thin, and there's not that camaraderie and communication that helps the young lawyers learn. Mm-hmm. It's another bone I have to pick with the current system. When I came up with law, I was mentored by the lawyers, the senior lawyers. They taught me uh, basically law school doesn't teach you how to practice law, they teach you the law. I was taught how to practice law, where to stand in the courtroom, what to say to a judge, and what to put down in black and white. Unfortunately, I see some of the young lawyers who don't have that advantage, and they come out of law school and they get thrown to the wolves without any guidance, and it's sad that's happening.
Well, some of them, I don't sense that they really want to be mentored or want someone giving them advice. But I sense that there are others that would greatly appreciate somebody giving them a bit of guidance or some ideas. What is your perspective? Do you think that's something people want or that they just could live without?
Well, if you're in a law firm that wants to mentor you and you don't want to be mentored, you're out of that law firm. They'll kick you out. But I think that the law firms now don't take time to explain to the lawyer the need to be mentored. And so I think it's more coming from the law firms not caring.
So we've entered a phase where law is no longer a profession, it's a business, true and complete.
True and complete, and I've cited the very same language. For all of those of you who have read Lee Engineering versus Fellows, you will see that the Supreme Court said that the practice of law is not a business, money-making business. And today, I'm afraid that whoever wrote that Supreme Court opinion is turning on his grave.
Yeah, but that was written back in 1968. That's been a long, long time ago. Um, I know it doesn't seem like a long, long time ago, but over 50 years, the world has changed a lot, maybe for the better, maybe not so much.
Well, I I don't agree with you in that respect. I agree with you that it's changed, but I don't agree that time permits the diffusion of the responsibility and the ethics and what the law practice is. And I think that the law practice should be today the same way that it was 50 years ago, the same way that it was when John Adams defended the British soldiers that did the Boston Massacre. And back then and today, it's taken seriously as a practice, as a profession. Not today anymore. I've had lawyers, by the way, when I was a mediator, that we were talking off the record, and they said they didn't care about the interest of the clients, they just wanted to make money. And that really shocked me and offended me.
And just so that everybody's clear, I want to be adamant about this. Judge Almeyda was not there when John Adams defended those soldiers. Um, is that correct? You weren't at that trial.
Sadly, I was the judge. And I don't know if you realize it, that got off with misdemeanor charges and they got deported back to England. But the point that I made is that the concept of the law practice being sacrosanct, because we're representing the livelihood and the interest of a litigant, be the one who pays or be the one that receives, should be the same. It should not be diluted by time, should not be diluted by technology. We as individuals should look at our responsibility towards that client and put that on a pedestal, almost as a holy item. And maybe I'm sounding old, and if I am, I'm not ashamed of it because I am who I am. But I take my responsibility seriously.
Yeah, and aren't we supposed to put the client's interest before the lawyers? This is all supposed to be about the client, and we're supposed to do what's right by them, even when that works, even a hardship or a tragedy on us personally as a practitioner, as a professional. That's just part of what we signed up for.
You're right. And I would dare say that the percentage of the lawyers in workers' comp, I don't know what percentage, don't agree with that. They believe the lucre comes before the responsibility to a client.
And I don't doubt that that's out there. Time and again, I have cited this, and I'll cite it again. But We do see a fair number of settlements every year where fees are being reduced or even forgiven, where lawyers are taking no part of the settlement for themselves. We see an awful lot of people anecdotally, I believe, who are doing a very fine job of representing their client's best interest and maybe putting time into a case that they're never going to get back out and never going to get paid for. And so that I'm clear, I'm proud of those people that are professional and dedicated advocates who really care about their client and about the process, even if it works to their detriment. I think they're still out there, and I'm inspired by them. All right, we've run up against the clock. That's about 50 minutes, and that's where we try to stick, is 50 to 60 minutes. I've put out in the chat box whether anybody had any questions today, and we've gotten no questions. I'll leave that for another moment as I wrap up. If you've got a question, type quickly. To sum it up, we've talked a lot today about professionalism. We've talked about the challenges with guardianships, emergency motions, some of these outlier situations, and I think we've had a very good conversation. We've gotten some compliments here in the chat box, Judge. One says, "Thank you for your time and perspective. Truly appreciated." So as this is listened to over time, I hope that it has a positive effect for folks. If you're watching this on YouTube, know that you can go to Spotify and download this as a podcast to listen to in your automobile. We do have them in a channel on YouTube, so you can go and look at any of those. And again, we're going to start putting up some trials that are interesting. I'd love to hear from the public if there is a trial that you participated in or that you've heard about, an appellate decision that you think you'd like to see the trial. Shoot me an email, and we'll be happy to process those videos and get them up on YouTube for your viewing pleasure. Judge Almeyda, thank you for joining today. I had a great conversation. It was wonderful to get your perspective on things. Anything you'd like to add and have the final word?
Well, just the last thing, maybe, well, I was taught in law school that the law is a jealous mistress. And looking back at 50 years dealing, well, 53 years, include law school, with this mistress, and she truly is a jealous mistress. It's been a great practice. I love it. And we're not for being a lawyer. I don't know what I would have been, because I love the practice.
Well, you'd have been an architect. We already answered that question, so we know that.
I can't draw a straight line and I can't draw a curved line.
That's wonderful talking to you today. I appreciate you being here. Thank you all for tuning in. I hope you have a great day.
Bye.